C-51, which was originally introduced as anti-terrorism legislation, is nothing of the kind. It is not. You will find very few references to terrorism in C-51. In the main, it is national security legislation, with national security defined in the broadest and most sweeping terms. It is really fair to say that we have not seen anything that has reshaped the landscape of national security in Canada so profoundly since we saw the first ATA, Anti-Terrorism Act, just post 9/11. Legal scholars and national security scholars have said that this legislation is quite radical. It introduces things into Canadian law that we've actually never seen before. Main components I just want to run by you, starting with the Security of Canada Information Sharing Act. So this is an omnibus bill. That means it changes all. It introduces new bills, new acts, and it also changes existing acts. This is a portion of C-51. I'm still going to call it C-51, even though it actually is, we've passed, right? It's an act. C-51 is the brand we all know. I'm going to stick with that. So the Security of Canada Information Sharing Act is arguably the piece of C-51 that brought out those thousands of people to various demonstrations, because people understood this was a broad-based surveillance bill. What it does is it allows the government, of the federal government, to information share for the purposes of national security, again, defined like we've never seen national security defined before, amongst 17 different federal agencies, including all the national security, policing, intelligence agencies, plus all the agencies that we are not used to seeing part of the national security landscape, like Health Canada, Canada Revenue Agencies, Veterans Affairs, etc. So the idea about sharing this information is clearly one of increasing the amount of surveillance in the national security sphere. But it's important to understand that we're not talking about discrete bits of information necessarily, where, say, CSIS could go to the Canada Revenue Agency and say, hey, we're interested in a couple of people here. Do you have some information on them? We'd like it for national security purposes. Now, that scenario I'm thinking very, very pointedly, because it was the news in a recent report that CSIS got whacked on the hand for doing that very thing. Hey, CRA, give us some information. We're just checking out a couple of people. The story on that was, hey, they weren't supposed to do that. They broke the rules. That was the headline. It should have been the headline, and now they can do as much of that as they want to. No, bigger headline. Now they can take the whole database. That's the part of C-51 that we really need to bring into focus if we're looking at the Security of Canada Information Sharing Act. Nothing requires individualized suspicion in this act. If I were the national security agencies, I'd go after whole databases, and that's the suspicion among privacy experts in this country. They're looking for databases. Why? Because we don't do national security the way that we used to. Now the movement, and this is the movement that has really been brought forward by our Five Eyes partners, our intelligence sharing partners, the US, the UK, Australia, New Zealand, and ourselves, is to collect everything. Why? Because we want to risk score everyone. Everyone is now a suspect in the national security paradigm. So the point here is, when we're talking about, surely we need good information sharing for national security purposes. That's very true. But the scope and the sweep of the Security of Canada Information Sharing Bill has got to be understood in relation to how broad those powers are, what they intend to do with them, and believe me, it will not be an individualized suspicion standard. You have to understand big data and big data analytics to know what they're planning to do with these large databases. So that's, as I say, the piece that has brought out a whole bunch of folks. style no-fly lists. Canada has had since 2007 the Passenger Protect program. We've had the Made in Canada version of the no-fly list. What the new no-fly list does is bring in two lists. And again, I just want to highlight here how there's been a little bit of confusion in the media. You know those small Muslim children who are apparently on the no-fly list? Remember that? They're not. They're on the slow-fly list. We have two lists. No-fly, the one that actually keeps you off an airplane. Slow-fly, the one that subjects you to further scrutiny on the basis of criteria that you can never know and never appeal. That's what those children are on, the slow-fly list. Our new no-fly regime gives you an incredible snowball's hope in hell of getting yourself off the no-fly list. You would have to apply in writing once you are unable to board an airplane. By the by, nobody will tell you that you are on the no-fly list. Right? We get very Kafkaesque here when we deal with no-fly. You'll just have to figure out that the fact you're not being allowed on the airplane is because you're from the no-fly list. You appeal to the minister and say, I shouldn't be on this list. The minister will ignore you for 3 months. That's considered an answer. And if they ignore you for 3 months, they consider that answer to be, no, you're fine. At which point, you can go to federal court. In federal court, you may or may not be told what you were put on the no-fly list for. In fact, they can hold the entire hearing in secret if they wish. This is the level of due process that the U.S. started out with that has recently been found unconstitutional in the U.S. We have decided on a no-fly scheme that mirrors what they started with, and we already know the horror story that has engendered. The slow-fly list sucks to the EU. There is actually no process to get yourself off the slow-fly list, and again, it is forbidden for you to even be told that you're on it. So this is the level of due process that clearly is ripe for constitutional challenge. But the further thing we need to note about the no-fly list, if we look to our friends in America to see what it is really for, given that there is no empirical data anywhere to support the proposition that this increases the safety of the skies, what it has been used for and is very effective for is recruiting informants. So we are seeing in the United States people waiting until people travel abroad, put them on the no-fly list so they can't come home, send intelligence agents to them and say, we're happy to put you to rights to get home on this airplane, provided you become an informant for intelligence. That kind of pressure is what no-fly lists are very effective at. As I say, no empirical evidence that otherwise they improve the safety of the skies. That's the second piece. The third piece is the extension of powers of preventative detention. Again, we could go on this. Preventative detention is an extraordinary power where you are, in fact, arresting someone on the basis of the suspicion of what they are going to do. Bill C-51, we've had this provision for some time, has extended the amount of time they can be held for and lowered the standard for that holding. And as well, we see the new speech offenses. So the new speech offenses include criminalizing the promotion of terrorism in general. You're asking yourself, what does that mean? And I'm telling you as a lawyer, no one knows. This is one of those places, again, where we have a concept that is absolutely novel in Canadian law. We don't know what this language means. This is obviously deeply of concern to all kinds of free speech advocates, but as well, it was of concern to security experts who say this is exactly the wrong way to go about looking at a national security program in which you want de-radicalization programs, you want to know who's who and what's what and who's thinking what. This is the wrong way to go about it. So arguably bad security policy, certainly just dire for chilling freedom of expression. And then finally, we have one of the pieces that everyone, again, is very concerned about, which is the radical reshaping and redefining of the role of CSIS. CSIS is our domestic intelligence agency. And since the McDonald Commission and the creation of CSIS, the thinking was that our intelligence agents should be separate from our national security policing. In part because while your intelligence agents it may be permissible, and in fact is arguably quite needful, that they do some of their work in secret to gather intelligence. Secret intelligence has some place in a democracy. Secret policing, no place in a democracy, which is why we created CSIS, so that its intelligence branch would give intelligence to policing arms that have to act transparently. Now, with CSIS given policing powers, kinetic powers, allowed to take measures to interrupt national security concerns, we effectively have a secret police. And so the concern about accountability, transparency, oversight, review, judicial authorization all spring from various aspects of C51, but are really harnessed in this final one, the recasting of our domestic spies as domestic secret police. Now, there is a provision in C51 for CSIS to go to a court to get a warrant if what they are planning to do in their disruption powers is likely to impact on the constitutional rights of someone. I'll tell you, legal scholars have had just a field day with this, absolutely a field day, because it is as if the drafters have fundamentally misconceived the role of the courts and the Constitution. Courts aren't there to sanction breaches of the Constitution. They're there to make sure breaches of the Constitution don't happen, right? So, unlike where you have a search warrant, where when the court sanctions a search warrant, it turns an unreasonable search and seizure into a reasonable search, because that's the nature of our right. We have a right to be secure against unreasonable search and seizure. But that's a very, very, very specific kind of right. Most of our rights don't have that qualifier. There is no unreasonable, cruel, and unusual punishment. It's all unreasonable. You can't quantify that, qualify it, by having a court order. So asking the courts to do that work is simply anathema, and for many legal scholars, a non-starter. And that would be one of the places that we are likely to see sort of low-hanging fruit for a constitutional challenge. But the entire framework of allowing CSIS to have this policing power is really the bigger container that this concern is in, and it certainly includes the warrant provisions.
The kind of chilling climate that we've seen in this country, not just because of this legislation, but because of other aspects of the previous government's legislative agendas that have been taken together profoundly, I think, anti-democratic. And I'd like us to focus on that as well, not just focusing on this particular, particularly problematic piece of legislation, but rather the constellation of tendencies and forces within the state that move in a very anti-democratic direction. People such as Frida Houston, Dini Togastai, people like Richard Wright, who represent the Una Stodenkamp and Maddie Lee Camp, respectively. These people, these indigenous frontline land defenders, are, I think, in my view, quite at risk of falling afoul of this particular law. And by the same token, we at the Institute would be implicated as well, insofar as we have had those particular speakers appear at a conference that we organized in the spring of 2014. Some of you actually were there, and it was called The State of Extraction, and it really looked at the manner in which the extractivist project of the previous government, remember, to make Canada into the new energy superpower, had played a key role in remaking aspects of the Canadian state. And we could talk about this in the discussion period, just how it has done this, the use of omnibus bills, prorogation of Parliament, the so-called Fair Elections Act, Bill C-24, etc. And of course, the current legislation that we're discussing today. This was all part and parcel of a transformation of the Canadian state to make it into this so-called energy superpower. So this is something that I think we really need to keep our attention focused on, is the fact that it isn't so much a matter of targeting for criticism a particular government, but rather looking at the larger institutional transformation of the Canadian state as such. And so the second part of my presentation was really to say that we see some evidence in this thesis globally, right? We see throughout the world a situation in which the right to dissent is now very much on the defensive. The right to dissent is being increasingly undermined. And the specific examples that I could point to are the following. There's the Italian student in Egypt. He was doing research on the role of Egyptian trade unions in challenging the existing government, who was apprehended, tortured, and then murdered by the security forces. There were 19 academics in Turkey who were recently detained for unpatriotic statements in favor in support of the Kurdish minority. And in India today, there is a tremendous crisis in higher education because of the recent arrest of the JNU student union president for apparently uttering seditious statements simply by voicing concern about the death penalty that was meted out to the leader of the attackers who lodged the attacks in 1993. Some statements of solidarity with people of Kashmir and solidarity for Rohit Vemula, who was a Dalit student who was apparently, and some say, driven to suicide by the actions taken by the University of Hyderabad's administration. So we see this as a global phenomenon, a global undermining of democracy, which I would argue is part and parcel of a new phase of neoliberalism. And we could talk about what that actually is in the discussion period as well, what neoliberalism is, but a new authoritarian phase of neoliberalism that now trucks no dissent. One of the things that Margaret Thatcher said about the neoliberalism that she was in the process of really bringing into the world in the late 1970s in Britain was there was no alternative. And this wasn't the case because neoliberalism was grounded in the best possible evidence as to how social policy should operate in the Western world, and now, of course, globally, but rather it was increasingly because of a tendency of the state in a very authoritarian way to shut down the possibility of any kinds of alternatives. I see this legislation and other forms as well, including the motion that was recently passed in the House of Commons last week, condemning the BDS movement, the boycott, divest, and sanction movement against Israel because of its lack of compliance with international law. It's very much part of these same tendencies. So I think we need to have this larger discussion of this legislation and not think that, oh, well, if it's repealed, everything's hunky-dory, because things aren't. The last point I would make, this government has signed earlier on in the month the TPP, the Trans-Pacific Partnership, which is going to place further restrictions on the democratic will of people of Canada. The Special Rapporteur to the United Nations for Indigenous Rights has argued that it is going to undermine Indigenous rights. This comes into absolute conflict with the recommendations of the Truth and Reconciliation Commission. These are the larger discussions we need to have, and we need to hold this government to their stated commitments. So I'll just stand there. Thank you.
On May 16th, 2015, both the Liberal and Conservative parties voted 183 for Bill C-51, defeating the 96, including the NDP, Green, Bloc Québécois, and Force Démocratique, who voted against it. The Liberals promised major reforms to the Act if they were elected, but despite the very large wave of Canadian public opinion mobilized to oppose C-51 last year, and which was a very definite ingredient to defeat Harper, we don't see any sign of the promises to do major reforms to the bill. They continue to defend the secret police powers, privilege, and impunity, all greatly expanded by C-51, and the Liberal defense of this orientation doesn't bode very well. Ottawa Liberal MP David McGuinty, brother of former Ontario Premier Dalton McGuinty, made a trip with Public Safety Minister Ralph Goodall to Britain recently to study British parliamentary oversight of their security apparatus. David McGuinty has been appointed to head up a committee to review oversight provisions with legislation possibly in June. Two things immediately come to mind. One, the very notion that rights, including rights to security, can be defended by police powers which are outside the rule of law is irrational. To study a model from Britain is even more preposterous and irrational, given Britain's long history as a colonial power whose use of secret police powers over a couple of centuries illustrate their mastery of using secret police as a key instrument of their divide and rule power in the colonies, including Canada. There are so many other examples of secret police activity by the British in Rhodesia, South Africa, Malaya, Greece, even Tsarist Russia, let alone modern-day Ireland, notorious H-block prisons leading to the deaths of many Irish patriots like Bobby Sands. During the Thatcher regime, that to look to Britain as a model of supervising security agencies really indicates how deeply Anglo-centric and colonial the liberal mindset is with respect to secret police agencies. When I had a chance to confront Justin Trudeau in person at a picket at a demo in Burnaby, we were demonstrating against C-51 when we were speaking, he defended his father's use of the War Measures Act as a means of ending terrorism in Quebec. When the Army occupied Quebec on October 16, 1970, some 500 persons were arbitrarily imprisoned without habeas corpus. What emerged during and after the event was the role of the political police in inciting these events, much as we see in the so-called sting operations of today. Through the history of state racist attacks in Canada and state terrorism, we have seen that without definite organized forces behind individuals and groups, their actions do not materialize, and this shows the role of the political police since the time of Borges and Cardinal Richelieu, the Tsars, the British, the French, Belgian, and Dutch colonists, and U.S. imperialists today. As concerns the events of Quebec in 1970, who was behind the murder of Minister Pierre Laporte is still shrouded in mystery. We do know that political institutions like the bookshelves of CPCML were smashed and their proprietors were beaten and thrown in jail. The passing of emergency measures for an apprehended insurrection in which the Commission on RCMP wrongdoings revealed the dirty and secret police were not an aberration. It's the Canadian way. The thread linking these historical events is the use of secret police security agencies to actually accentuate problems that by their very nature should have been approached in a political manner through consultation, negotiation, and the affirmation of basic rights. What we have is that the arbitrary police powers define the rights which are permitted in what is called the government of laws. In my opinion, the people should provide a modern definition of rights, and governments must be duty-bound to uphold them. This is not presently the case. Since Canada was founded, the arbitrary powers, the Queen, the prerogative, the royal prerogative, the authority of executive of the state, have defined rights. This is why when Trudeau Sr. finally enshrined them in our Constitution, he also enshrined reasonable limits defined by the arbitrary powers, including, of course, the section that allows provinces to opt out of the Constitution, the notwithstanding clause. Now, in the post-Cold War, post-9/11 period, the particularly egregious features of C-51 and the crimes against Arar and many others, which Micheal and Samir have referred to, make C-51 not amendable. Therefore, the necessary no to repeal C-51 remains a political task. But what is the yes we need to organize and discuss to counter the expanding arbitrary surveillance security state here and abroad? Unless we have a rule of law which recognizes our no, our yes will remain meaningless. The rights permitted in the civil society were defined by the arbitrary powers in the first place, and now even they are becoming meaningless as a result of the interests of private owners of immense wealth and privilege. We need to make our no effective. Taking the blinds off what C-51 and the entire discourse on state anti-terrorism really means is an important task, as is organizing the public in political discussions and assisting our fellow citizens to acquire the confidence and courage to defend their rights, the rights of all, and actively stand up against agencies like CSIS, the RCMP, CSE, the border agencies, and so forth. The more the public take to meetings, discussions, and the streets to push forward their agenda, like stopping the irrational Site C proposal, to name but one, the more this yes for a renewal of democracy and empowerment of the people advances. The faster we tie down the Liberal government and have C-51 repealed. Imagine the Lilliputians in Gulliver's Travels tying down the giant Gulliver. Or reflect on Bertolt Brecht's poem In Praise of Learning, which concludes, "Don't be afraid to ask, comrade. Don't be talked into anything. Check for yourself. What you do not know yourself, you don't know. Scrutinize the bill. It is you who must pay. Put your finger on each item. Ask, how did this get there? You must take over the leadership."